Hello everyone and welcome to the February 2024 episode of My PIP Monthly. As always, my name is Amber Ross Holloway. I'm an executive partner here at our Troy office, and today I'm joined by my fellow partner Zachary Diedericks, who is a partner here at our Troy office. For our February 2024 topics, we'll first start off with a case law update. I'll be discussing the case of Johnson v. Smart, an unpublished opinion of the Court of Appeals, which was recently issued on November 16, 2023. Then I'll move on to Belmore v. Friendly Oil Change, opinion of the Michigan Supreme Court that was issued even more recently on February 7, 2024. And then Zach is going to take over for trending topics in PIP litigation, and he's going to discuss the State of Michigan Department of Insurance and Financial Services most recent bulletin. So first up, we have the case of Johnson v. Smart. Like I said, it's an unpublished opinion that was issued in November of 2023. Essentially, this case highlights that a public bus driver does not have a duty to wait for passengers to be seated to begin driving unless there's some special or apparent reason the driver should know a passenger is incapable of protecting him or herself from injury. Ultimately here, plaintiff was unable to show any evidence indicating that the bus driver should have known to wait for the plaintiff to be seated to begin driving. Now, just a bit of background on this one. After standing to speak to the bus driver when the bus was stopped, plaintiff let go of a pole that she was holding on to, and she let go of it in order to sit down. Before she was able to sit, the bus accelerated, allegedly causing her to fall and sustain injuries. The bus driver, it was his opinion that he accelerated in a normal course of driving. It was just a typical starting of the bus after a stop. Thereafter, plaintiff filed suit against Smart, alleging 1, defendant was vicariously liable for negligence by the bus driver, and 2, defendant was negligent in its hiring, training, and supervision of the bus driver, and 3, defendant's liability for payment of PIP benefits arising from plaintiff's injuries. I won't really go into plaintiff's injuries here, as I don't believe they're that important to the holding of the case. What's more important is that she did not have any visible injuries or disability that the bus driver saw. Throughout the case, or following discovery, defendant moved for summary disposition, alleging that plaintiff's negligence claims were barred by the usual incidence of travel doctrine. And that, under Michigan law, indicates that a sudden stop or start does not constitute negligence. In contrast, plaintiff argued that under the doctrine, the bus driver still possessed the duty to exercise ordinary care, and the driver breached that duty by making an unnecessarily sudden start. Throughout discovery, like I said, the driver testified that it was not an unnecessarily sudden start. It was just a typical start after being stopped for a short period of time. Now, here the trial court denied defendant's motion for summary disposition with respect to the usual incidence of travel doctrine, finding that a reasonable juror could find that the bus driver may have been negligent. And this appeal followed. Now, here, unless there's some special and apparent reason, a public transportation operator does not have a duty to wait for their passengers to be seated to accelerate. And that's the case of Oettinger v. Detroit United. And these are all defendants' arguments, but plaintiff argued that because the bus driver knew she was standing and trying to sit down, that constituted a special reason the bus driver should not have accelerated the bus. Now, the Court of Appeals disagreed with plaintiff, finding a special or apparent reason exists when a passenger's physical appearance would indicate to the driver that the passenger is frail, weak, or otherwise disabled in need of assistance. And that simply wasn't here. The Court of Appeals further agreed that plaintiff could not show that the bus driver made an unnecessarily sudden or violent start to exclude the incident from being barred by that doctrine. Now, this case ultimately addressed whether a negligence claim resulting from sudden jerks and jolts of a vehicle were barred under this usual incidence of travel doctrine. It's a somewhat uncommon doctrine to use in a no-fault case, but situations like this may become more prominent due to no-fault reform, limiting reimbursement, and such cases as premises liabilities, which have been narrowed recently. So you'll see more litigation with seemingly normal circumstances start to arise in the courts when situations like the no-fault reform or the narrowing of the premises liability occurs. Now, the Court of Appeals here overturned the trial court's denial in part of Defendant Smart's motion for summary disposition, finding that it's normal for a public transportation driver to begin before passengers are seated, and therefore no special reason was found, and the bus driver was not required to wait for the plaintiff to sit in this instance specifically. And moving on to the Belmore v. Friendly Oil Change case, this is a Supreme Court opinion that was issued February 7, 2024. Now here, the Court of Appeals was reversed in its conclusion that plaintiff's injuries did not arise out of the maintenance of her motor vehicle as a motor vehicle as defined by MCL 500-3105, Section 1. Now this case centers around getting an oil change and falling into an oil pit. Again, this is kind of a nuanced decision, but I know that certain people have, I have an irrational fear of falling into a ditch every time I get my oil change. I remember the very first time I got my oil change when I was around 16 or 17, and I pulled in and immediately, for some reason, opened my car door, and then all of the employees were yelling, telling me to get back in the car, and ever since then, I feel like I've had this irrational fear. Well, that is exactly what happened in this case. The plaintiff here fell into an oil pit while getting an oil change. But ultimately, the Supreme Court held that injuries sustained while walking over to examine an old oil filter at an oil change facility arose from the maintenance of a motor vehicle as a motor vehicle. And therefore, the No-Fault Act applied to this incident and injuries, and plaintiff was entitled to receive PIP benefits due to this specific incident. Additionally, the court clarified that MCL 500-3106 Section 1 did not independently provide no-fault benefits, but rather excluded coverage for injuries involving parked motor vehicles unless certain exceptions applied. Again, here, this incident occurred when plaintiff tripped and fell into a service pit or the oil change facility while her car was being serviced. Plaintiff was asked by the service technician to walk over to look at her old oil filter and approve its replacement. And then on her walk over to look at that filter, she fell and tripped into the service pit. Now here, the court reasoned that the service pit, akin to like a hydraulic lift or a jack, facilitated vehicle maintenance by providing access to certain parts, thus establishing the causal relationship between the injury and the maintenance activity. Additionally, the Court of Appeals judgment, which addressed personal protection insurance benefits, PIP benefits, was also vacated. The court clarified that MCL 500-3106 Section 1 does not independently entitle individuals to no-fault benefits, but rather operates as an exclusionary provision, barring coverage for injuries involving parked motor vehicles unless there are certain exceptions, and there were no exceptions here. Notably, the court here emphasized that when injuries stem from maintenance of a motor vehicle, analysis under MCL 500-3106 Section 1 becomes unnecessary. And I did want to include, which I don't often do, but some of the dissents or some of the justices' opinions. Now here, Justice Zara concurred with the majority's findings regarding the origin of plaintiff's injuries, but dissented concerning the interpretation of MCL 500-3106 Section 1, instead advocating for a narrower applications based on the vehicle's park status. And Justice Bernstein recused himself from participation due to a familial interest in the matter.
On January 17, 2024, Anita Fox, who is the director of Michigan's Department of Insurance and Financial Services, otherwise known as DIFS, issued a bulletin 2024-06 INS, which tends to support the position that the fee schedule under MCL 500.3157 sub 2 through 6 applies to services provided despite a pre-reform accident. Now, a bit of background, as we know, in an effort to control the cost of auto insurance, the Michigan legislature significantly overhauled the Michigan No-Fault Act in 2019. As it relates to today's segment, MCL 500.3157 was amended in several respects, in part to prevent no-fault treaters from overbilling no-fault carriers. MCL 500.3157 sub 2 states that, subject to subsections 3 to 14, a physician, hospital, clinic, or other person that renders treatment or rehabilitative occupational training to an injured person for an accidental bodily injury covered by personal protection insurance is not eligible for payment or reimbursement under this chapter for more than the following. A, for treatment rendered after July 1st, 2021 and before July 2nd, 2022, 200% of the amount payable for the treatment, Medicare. B, for treatment rendered after July 1st, 2022 and before July 2nd, 2023, 195% of the amount payable for the treatment under Medicare. And C, for treatment rendered after July 1st, 2023, 190% of the amount payable for the treatment under Medicare. Following the enactment of the amendments, the question then became, does this fee schedule under subsection 2 apply to all treatment rendered after July 1st, 2021, regardless of accident date, or only to cases where an accident occurred after the effective date of the amendment, June 11, 2019? In the landmark case, Andry v. USAA Casualty Insurance Company, 512 MISH 207, 2023, the Michigan Supreme Court addressed this issue with respect to subsections 7 and 10 of MCL 500.3157. Subsection 7 of 3157 involves scenarios where treatment or occupational training under subsection 2 is not reimbursed by Medicare, and subsection 10 of 3157 involves family-provided attendant care. In Andry, the Supreme Court held that subsections 7 and 10 do not apply where the accident occurred after June 11, 2019. So, where a person is injured in an accident before June 11, 2019 and continues to receive medical treatment, the pre-amendment language applies, not the newly amended sections 7 and 10. However, the recent Diffs Bulletin highlights that the Supreme Court's ruling in Andry was expressly limited to 3157, subsections 7 and 10. In other words, Andry did not say that the no-fault amendments never apply when the accident occurred before June 11, 2019. Basically, they said that this decision only applies to subsections 7 and 10 of 3157. So, how does this affect the application of 3157 subsection 2 for treatment provided after July 1, 2021 and where Medicare reimburses that treatment? In a Michigan Court of Appeals decision to be published entitled Giramonte v. Liberty Mutual Insurance Company, the Michigan Court of Appeals included the following in footnote 6. In Andry 1, which is the Andry decision at the Court of Appeals, this court held that 2019 PA 21's amendments of MCL 500.3157 sub 7 and 10, which, as we've already discussed, caps attendant care expenses and imposes new fee schedules for certain services where Medicare does not reimburse, was not to be applied retroactively. Our Supreme Court, otherwise referred to as Andry 2, affirmed this court's holding on that point. Both cases, Andry 1 and Andry 2, explicitly state that the issue before this court and the Supreme Court was the retroactivity, or lack thereof, of the amendments of MCL 500.3157 sub 7 and sub 10 as opposed to 2019 PA 21 in its entirety. So, as you can see, in Giramonte, the Court of Appeals went out of its way to reiterate that Andry only applies to sections 7 and 10 and not the entire reform, otherwise known as 2019 PA 21. Further, pursuant to Michigan law, an opinion of the Supreme Court or Court of Appeals cannot create precedent as to issues neither briefed nor argued. This is outlined in Quinton v. General Motors Corporation 453 MISH 63 at 74, 1996. Further, pronouncements without briefing and argument are not stare decisis. The essential principles of stare decisis include that an issue of law must have been heard and decided, and if an issue is not argued, or it's ignored by the courts, or is reversed, the decision cannot constitute precedent to be followed. This is outlined in EEOC v. Trabucco 791 F2D 1 and 4 CA1 1986. So what does this mean? Does this mean that MCL 500.3157 sub 2 does, in fact, apply to treatment that occurs after July 1, 2021, but before an accident that occurred prior to the reform? Not necessarily. The issue has not yet been decided, which is why it's a trending topic in PIP litigation. However, there is certainly authority to support the position that it does. As we've just discussed, because Andery only addressed 3157.7 and 10, Andery is not precedentially binding on the rest of 3157 or the rest of the no-fault amendments for that matter. Therefore, until the issue is decided, where applicable, defense attorneys should always raise the issue of subsection 2's applicability, regardless of when an accident occurred under the plain language of the statute, which states specifically for treatment rendered after July 1, 2021, etc. A finer point involves no-fault provider lawsuits. Although Andery only addressed subsections 7 and 10, much of the decision hinged on an insured's contractual rights. For example, the Supreme Court stated, "The insurance policies covering plaintiffs Ellen Andery and Philip Kruger bind the insurance companies to their promise to provide PIP benefits under the law that existed at the time of injury to those individuals covered by the policies." The 2019 no-fault amendments do not clearly convey an intent to retroactively modify these vested contractual rights. Andery and Kruger are covered by policies under which premiums were paid with the expectation that uncapped lifetime benefits would be provided for all reasonable and necessary medical expenses. Their vested contractual right to continuation of those benefits at pre-amendment levels cannot be stripped away or diminished when the legislature has failed to clearly state its intent to do so. However, clearly a difference between an insured and a medical provider is just that. Medical providers are not insureds under the insurance contract. And in fact, MCL 500.3112 provides healthcare providers with a direct cause of action, meaning the provider's claim is not a contractual claim, but a statutory cause of action. Therefore, it could be successfully argued that, absent an assignment of rights, a healthcare provider cannot stand in the shoes of an insured. In other words, without an assignment, a healthcare provider cannot rely on the contractual rights of the insured as contemplated in Andery. Further, in Spine Specialists of Michigan PC v. Member Select Insurance Company, the Court of Appeals held that a medical provider's claim is incurred when the injured party received medical treatment from a plaintiff and the claims for those services accrued at that time. The panel in Spine Specialists held that a court is to look at the law in effect at the time the claims accrued. So, based on that, there appears to be an even stronger argument that subsection 2's fee schedule applies to medical providers outright, but even more so where an assignment of rights has not been executed. Perhaps we shall see.
I did want to comment on something Zach just recently said. I recently did have some success in a motion for summary disposition where I argued that in a 2017 motor vehicle accident that the fee schedule did apply. And specifically, I argued that the fee schedule applied if there was a corresponding Medicare code. And this was on a provider suit where the plaintiff was claiming approximately $123,000 worth of benefits, and the fee schedule capped it down to about $12,000 worth of benefits. So it's definitely worth arguing, even though we do not have, clear and concise direction from the courts. It's worth an argument because if we don't have that clear and concise direction, neither do the judges. So it's definitely worth a motion for summary disposition. And it's always good to just determine what the fee schedule calculations are at the onset of litigation in those provider suits, just for situations like this. And that is all we have for you guys today. As always, thank you for attending my PIP Monthly. Please feel free to contact me with any questions or comments. Thank you.